Welcome to American Advantage Law Group Landlord Tenant Law webinar. The goal today is to shed light on how to prevent mishaps and act appropriately when mishaps do occur without ever overstepping the legal parameters designed to protect both landlords and tenants under the cloak of tenants' rights. The Fair Housing Act makes it illegal to reject tenant applications based on discriminatory reasons. Discrimination based on race, color, religion, national origin, age, familial status, physical or mental disability is illegal. Although it may seem straightforward and obvious that all living conditions must be safe and clean for tenant use, disputes often take place on such matters. It is often mistaken by the tenant that a gross infestation of rats or cockroaches is justification for the break of a lease. Contrary to popular belief, if the infestation or poor living condition is a result of the tenant's lifestyle, then the tenant is financially responsible for the correction and it provides no grounds to legally break the lease agreement. It is, however, the landlord's responsibility to respond to a tenant request regarding the treatment of the inhabitability issue, and the bill may be forwarded from the landlord to the tenant. Landlords are required to give their tenants privacy. This means that the landlord himself or anyone associated with said person needs to obtain permission before entering tenant dwellings. There are only 3 situations in which landlords are legally permitted to enter tenant dwellings. Number 1, for repairs after sufficient notification to the tenant. Federal law defaults to statutory law on what is considered sufficient notification, but use 24 hours as your rule of thumb. Number 2, emergency. This includes fire and flood. In these situations, forget the 24-hour notice. Number 3, to show potential renters or purchasers the property. Again, sufficient notification is required. Also, make sure the tenant is actually notified. Missed phone calls do not count. It is also important to know the maintenance responsibilities of the landlord, and the consequences of these responsibilities are ignored. The landlord must provide adequate weatherproofing, heating, water, hot water, electricity, and a clean sanitary environment. The final highly common issue in the world of rent is who is responsible to pay rent in certain situations. The parties to a lease are any person who signs the lease agreement with the landlord. Any person who signs is responsible for the total amount of the rent due, so the landlord can pursue any roommate for the entire amount. If you, as a roommate tenant, pay your share of the rent, your obligation is not over until your roommates or someone pays for their share as well. However, landlords can only collect the amount owed, so they cannot collect the full amount from multiple tenants. Disclaimer: this is an information seminar only. The American Advantage Law Group does not make any warranty regarding the up-to-date information provided. Our law office does not render any opinion regarding any specific case. This presentation does not establish any client-attorney relationship. If you have any questions regarding your specific case, we strongly recommend you seek an attorney's advice. Please feel free to contact us in Newport Beach at 3848 Campus Drive, or by telephone at 1-949-863-1888, or by email at americanadvantagelaw